This is Agriculture Today. I'm Samantha Bennett with the K-State Radio Network. Ahead of us on this Wednesday's program, we have Kansas State University and Washburn University School of Law's Roger McEowen covering two Kansas Court of Appeals cases for us this week. We also have Ryan Rastok. He's a forest health coordinator with the Kansas Forest Service, providing valuable information regarding uprooted trees. Lastly, to round out today's program, we have our first horticulture piece for the week on onions from K-State horticulturalist Ward Upham. That and more ahead on this edition of Agriculture Today. Welcome back to Agriculture Today. This Wednesday morning, we have with us Roger McEowen from the Washburn University School of Law for our bi-monthly segment on ag, law, and taxation. So, Roger, thanks for joining us today.
Good to be with you, Samantha.
We're going to walk through two cases today, Roger. So the first and foremost one, a case of tacking, and then the second one, a case of easement. Both of these came through the Kansas Court of Appeals this year. So let's start with that first one, the first one dealing with tacking.
Yeah, this issue of tacking is several times a year, and what it involves is adverse possession or boundary by acquiescence, and that is when I own my property for a certain amount of time, and I discover that my boundary with my neighbor is not really on the surveyed line. It's, we've been using our properties, our respective tracts, up to a particular area, a particular line. Maybe I have farmed up to that line on my side. My neighbor has farmed up to that line on their side, and we just kind of assumed that that was the boundary. And then, or maybe we have a fence between us, and we just assumed when I bought my property, I assumed that that was on the actual line between the property, and we never really had it surveyed, and that's kind of common in agricultural settings. But at some point in time, a survey is done, and the parties realize that their usage where they treated the line is not really the actual legal surveyed line between the properties. And so then the question comes up, if you haven't owned your property and used it that way for the statutory time frame of 15 years in Kansas, which is the adverse possession statute, can I take the time that I've owned it and used it that way and add on to that my predecessor's time of owning and using the property in that manner? And if that use is consistent, in other words, my predecessor used it the same way that I'm doing, it's possible to add their time to my time to get to that 15-year requirement, and then I can file a quiet title action and have that disputed area quieted title in me.
Sure. So there's a key word here being used in this case specifically, and it's adverse possession. You hinted at it a minute ago, but versus acquiescence. So really, what's the difference between those two terms here that listeners should know?
There is a distinction between two. Often courts, not only in Kansas but elsewhere, will blur the concepts. We get to the same result, but it is a little bit blurry how the courts get there. I cringe every time I read one of these cases because that terminology is not correct. The distinction is this. If I know where a property boundary is at, I know where the legal property boundary is at, and I decide I'm going to use the property on the other side of that boundary. I'm going to use my neighbor's property. That is clearly adverse possession to them. I am adversely possessing their property. I know where the boundary is, and I have with intent and out in the open, I'm adversely possessing their property. I'm using it. I'm farming on it. And the rule is if that person knows that you're in the open, you're adversely hostile to them in terms of your use of their property, and they see it and they don't do anything about it for 15 years, which is the statutory time frame in Kansas, then they can lose that property if you file a quiet, or if I file a quiet title action to quiet title in that area that I'm adversely possessing. And it really, that concept comes from Old England centuries ago, and the terminology is squatters' rights. And so if people would see people coming onto their property and using it, and then they didn't do anything, the common law courts in England centuries ago said, well, you've got to assert your rights, and if you wait too long, you're going to lose it. Well, that property law concept carried over into the United States. So that's adverse possession. Boundary by acquiescence is close to this, but it's just kind of the opposite. That is where we don't really know where the property boundary is at. Nobody's had a survey. We just kind of treat a particular line, maybe a line of trees, maybe a hedgerow, maybe a convenient place to turn a tractor and equipment in a field. And my neighbor and I just treat this common line as the boundary. So we're just assuming that, and lo and behold, it turns out that it's not the boundary. Well, that's a boundary by acquiescence. We just kind of agreed to that. There's no intent to adversely property. But the courts will blur those concepts, and they'll say, well, if a subsequent survey reveals that what you were treating as the boundary is not really the boundary, then whatever party it benefits can file a quiet title action and get the disputed area titled in themselves. So you get the same result. It's just a different concept, one in which where we know where the boundary is. The other one applies when we really don't know where the boundary is.
Very interesting history to those terms, for sure. So we also have, this 15-year requirement that was obviously met here. So the owner or the defendant had possessed the strip of land for 8 years and then claimed that the prior owner before him had it for at least 7. So that met the 15. Is that 15 standard to all states, or is that just to Kansas?
Well, in some states, Kansas is one of the states that has a 15-year requirement. There are other states that have a 15-year requirement, but it's not common in all the states. No, states will vary. In some years, in some states, it can be as little as 2 years. So some states are 7, some are 10, some might be 5. It's just all over the board. So 15 is one of the longer statutory timeframes that's out there. I think there's one state or two that's at 20 or 21 years, but 15 is one of the longer timeframes that the states use. So you just have to be aware of what your particular state statute is on that.
Absolutely. So let's get into the second case now, Roger. This one having to do with the removal of vegetation within easement proper. So talk us through this one.
Well, this is a case that comes up. It's an issue that irritates a lot of farmers that are along an abandoned railroad that where the rail line has abandoned it, and now a nature conservancy or trail group has taken it over. And that irritates a lot of farmers because the way the rules are at the federal level, the Rail Trails Act, nature group gets an easement, and the landowner really can't do anything about it. Now, there's litigation that has been through the U.S. Supreme Court in years prior in terms of when a railroad abandons a line, does the abandoned line revert back to the adjacent owner? In fee simple, can a group come in and have an easement over the farmer's land to run a trail on that former rail line? And the answer to that depends on state law. It depends on the original property right grant that the railroad received. Did they get an easement? Did they get fee simple title ownership? That's a separate issue. I'm not talking about that one today. But the issue in this case is we have an easement, and so we're not disputing that. What can the nature group do with that easement? And here, what they wanted to do was trim trees and vegetation, and within that easement. Now, they had a 66-foot easement, but they only needed about 10 to 14 feet of width to properly maintain and operate their trail. So here we've got a dispute. You've got a landowner that's got trees that he does not want cut down. He's got other vegetation that he does not want removed. And you've got the trail group saying, well, we've got a 66-foot wide easement. We can do whatever we want within that easement. And so that's how it gets teed up in court.
So for this one specifically, it wasn't a question of do they have the right to take this land, to use this land. It was more of a right of how much do they have access to in terms of their use. Is that correct?
That's right. Yeah. The question was, well, rights with this easement. And again, we're dealing with the scope of the easement. And what I tell people is when you grant easements over your farm property, and we get a lot of these in agriculture. It might be an oil pipeline, it might be an electrical line, it might be some type of utility, and we have these easements. Well, when we draft easements from an attorney standpoint, we want to be pretty clear in the easement language what the easement holder can do. I don't want to grant an easement over my property for somebody to get access to a farm field, and then they start developing that easement, and it really creates issues for me. So I want to be very specific as to what's allowed and what's not allowed. I want to keep it as narrow as I possibly can, and that's how we can avoid a lot of these problems. Now, in this situation, all you had was the width specified. You didn't really have any language that said what the Conservancy could do, what the nature group could do within that 66-foot width. And so that got us a lawsuit because now we're battling over trees and vegetation. And the bottom line on this is the principle that carries in just about all of these cases, and that is it's a rule of reasonable use. And the court came down on that issue. They said, well, yeah, the nature group has the right to trim trees and vegetation. And so the landowner was wrong in saying that they didn't have the right to do that. No, they do. They have an easement. But the Conservancy was wrong. The nature group was wrong in saying that they could do anything they wanted within that 66 feet. And what the court said, and this is the principle that we see repeated over and over, said it's a rule of reasonable use. And whatever the nature group needed, the trail group needed to properly operate and maintain that trail, they could clear vegetation, they could clear brush to do so. And the court looked at this and said, you only need to use 10 to 14 feet of the 66 feet. You don't need to go beyond that. And so they struck a middle ground, and it's a middle ground of reasonable use. And that is the rule. When you don't have specific language in an easement, that's the rule the courts will use. It's a rule of reasonable use.
That was Roger McEowen, professor of agricultural law and taxation here at K-State and from the Washburn University School of Law, covering 2 cases from the Kansas Court of Appeals. We'll be back with more ahead here on Agriculture Today. This is Agriculture Today. We're back now. We're going to be covering a little bit about tree health and the measures we can take to protect trees for future storms. To cover this topic, we have Ryan Rastok. He's the Forest Health Coordinator with the Kansas Forest Service. So getting into our first question here, we've had some recent storms with some tree damage, and in that damage, we saw a lot of down large trees that were completely uprooted. This might speak to the severity of the winds that we saw, of course, but why did the trees actually come down? Were there weaknesses that potentially developed?
Certainly. So there are a lot of contributing factors to why trees fail. If enough force is applied to a tree through a storm, wind, severe weather, that can apply enough force to those trees where the whole tree will either uproot and fail or parts of those trees will fail. And so we'll see this as in the case with the storm this past, was that last week in Manhattan there, when that was more of an issue with the wind forces. But, in wintertime, you can have issues with force being applied to trees with ice or in some cases, heavy rains and things like that. But for your whole tree failure, oftentimes that's more of an issue that you're seeing a failure of the root plate and at the roots. And so in urban areas, we run into some conflicts with trees that tend to compromise those root systems. A lot of people don't really consider it too much, but the roots of trees don't really go very deep into the ground. They're more shallow and expansive. I like to tell people it's more like the base of the stem of a wine glass, but very wide, oftentimes in a natural setting going far beyond the drip line of the tree. And so, if you or any of the listeners here go outside and look at trees, you'll notice that they're confined usually to various impermeable surfaces with roads, retaining walls, houses, building structures, so on and so forth. And so those roots are really constricted. And so the wider and the healthier that root system is, the better it's going to be able to withstand those wind forces that are applied to it. And so oftentimes it's a compromised root system through some sort of human activity.
So affects more urban areas more so than rural.
Obviously, trees can topple over in rural areas as well, especially with high flatline winds or tornadoes. But it all just kind of depends on the history and the site conditions and the soils and things like that too. But it is possible you'll have a more likelihood of some full tree failures if that root system is restricted.
These trees going down, does this indicate a danger that landowners, homeowners, or potentially even others in the vicinity of these larger trees should be aware of?
I think awareness is always very important, especially when it comes to trees. But in terms of, is this going to be a chronic issue that we're going to deal with? That's more of an acute condition with those storm conditions. And so if you really think about it, there are hundreds of thousands, if not more, trees there in Manhattan. And so the number that kind of topple over, it took a pretty extreme weather event for that to happen. and then to cause some significant damage to property. Tree risk assessment, we refer to those things as targets. Trees do fail, they do fall. It's a natural part of the system, but is it something that people should be on high alert about? Probably not, unless they have an indication or that tree's been assessed by a professional who can give some competent assessment of those trees. But in general, trees don't pose a major risk in most cases, but can under the right conditions.
If landowners and homeowners are listening to this and thinking, well, what should I look out for in terms of risks associated with the trees on my property specifically?
Right, yeah. And so with risk, we're really talking about our tree risk assessment. We're really talking about a few different things, talking about the potential for that tree or part of that tree to fail. And then if that tree were to fail, what is the likelihood of that contacting a target? So a person, place, or object or some sort of infrastructure, the likelihood of, in the event of a failure, what is the likelihood of that actually impacting something we care about? And so that's a very systematic process that if somebody were concerned and they saw some defects in those trees, a significant amount of decay on the trunk or up in the limbs or previous large branch failures or some heaving at the root plates, then that could probably warrant calling in a professional, either a certified arborist or a tree risk assessment qualified arborist to come in and evaluate the severity of that to provide mitigative option through pruning or removal or some other kind of means there.
Is there anything that can be done ahead of these potential storms by either the individuals or city officials themselves to reinforce these trees or potentially reduce the danger of them coming down?
Yeah, so it's a very complicated process because there's a lot of variables involved. The different species of the trees, the location, the history of the site, and then whatever event or events might contribute to something failing and causing an issue. And so, really it would take a competent person to be able to come in and evaluate what the degree or the likelihood, the risk might be. But then it's also up to the city managers or the people who own the trees to be able to really think about what their risk tolerance is, right? So there's always a little bit of risk with trees. I think it's usually pretty low unless something's very, extremely wrong with those trees or a severe weather event comes in. But really evaluating what your risk tolerance is, and then once you kind of determine that, talking with a professional who can kind of articulate the degree of risk that tree might have, and then if it supersedes your tolerance for risk, then promoting some potential mitigative efforts, either through some pruning or support structures, cabling and bracing, various things like that, or in some extreme cases, removal of the trees. And so really it's kind of putting all of those factors together in a systematic way.
Kind of following along those same lines, if it's inevitable that a tree could potentially fall, is there anything we can do to prevent it from falling on certain areas of property or areas where there's fence lines, buildings, equipments?
So a tree with, we would call that an imminent likelihood of failure. And let's say that, if that tree is if it's actively failing, going to fall over, we see a piece actively, let's say it's splitting in half actively, then, we would want to determine if that or when that does fail, because we're saying that it's imminent, is that going to contact or a structure or something like that, and what do we do about it? So in some cases, there's so many different scenarios that it's hard to kind of generalize. But in an imminent likelihood of failure, it's something you would really want to get somebody, a professional there, as quickly as possible, checking to make sure that they're, competent, they know what they're doing, and then have the insurance and credentials to be working in these high-risk situations. And that could come in any number of forms, from, if possible, while it's failing, figuring out how to remove that and mitigating the impact as it comes down, or providing a support system or something like that. So it would really be situational, but it's about getting somebody eyes on the ground to kind of assess those things.
So the importance of having someone qualified to speak on what to actually do for next steps is obviously what is important here.
Absolutely, because it really is. There's a lot of nuance involved, and it's not something we can very easily just like put a number to, like a percentage of, this is, a number of 20 out of 20 in terms of risk and danger and failure potential. That can be pretty dicey. And so we're just talking in terms of, probabilities, and that really, to be able to get that information and articulate that to somebody, and then also provide suitable mitigative responses really requires many years of experience with the species involved in the location, and then kind of knowing what the failure potential of those things are, and then knowing what you can and maybe might be more difficult to do to mitigate, either to retain that tree or to remove it.
And then because this topic to have a vast knowledge and understanding of, we're not trying to implicate anyone that they've done anything wrong in terms of landowners or anything like that. But is it fair to say that this is something that just naturally happens in a tree's life cycle? Is there a point at which they reach this part of their life where it's like, well, inevitably they're probably going to come down?
So trees, being, biological, living organisms, they tend to have a lifespan, and then how the fruition of that lifespan in a natural setting, what happens to that tree once it's kind of aged out, if that's kind of what you're getting at. Usually in a perfectly natural, healthy situation, say a bur oak, it's several hundred years old, and it's, kind of meeting its maximum lifestyle. They'll go through this retrenchment process, usually kind of slowly die and drop limbs and branches that they don't really need so much. Not that it's a conscious thing on the tree's behalf, but they'll kind of slowly do that. But really for the whole tree failure, I wouldn't say that it's an inevitability that, all trees will fall down at some point in time. It just is completely dependent upon the situation. But, in a perfect situation where that tree's in the optimum environment, typically it'll kind of die back slowly, probably not have a whole tree failure. But it also must be noted that a lot of our activities, improper pruning practices, but also land development issues can increase the likelihood of these trees having whole tree failures. And so I'll kind of articulate what I mean by that. So in the woodlands, if you go out there and you look at all of those trees in a natural setting, if they grew up in a forest or something, typically they'll be growing straighter. They're in competition, so they're not putting out those low limbs that you typically see with urban trees. They're not really adapted to a lot of the wind forces. Say if the town is kind of sprawling out into some of these more rural areas that maybe had trees, sometimes folks want to retain those trees that kind of are more adapted for those forested situations. And the issue is that once you start removing all of the surrounding trees or around those woods-grown trees, they tend to increase the likelihood of failure because they're just not adapted to those situations. I know after these storms, it can be very traumatizing for people who have experienced these tree failures. But we also need to kind of keep into perspective that it's more the exception to the rule than the rule. In general, trees aren't there's always some level of risk, but, it's not something to be scared of trees around your house or anything like that, unless there's a reason to be through a known or identified defect or something like that. So
that was Ryan Rastok, Forest Health Coordinator with the Kansas Forest Service. We'll be back with more ahead on Agriculture Today.
This is Agriculture Today. Along with Samantha Bennett, I'm Jeff Wickman. Onions that were planted in the spring are just about ready for harvest. K-State horticulturist Ward Upham discusses how to properly pull onions, including signs that they're ready for harvest and tips for storing onions to extend their use. Ward, an opportunity to talk about the fact that we're getting close to the time to start pulling onions, and there's a process that goes along with this.
That's right, and it depends on what type of onion you have, whether it's time to pull them or not. If you have some of the onions from sets, you may be really, really close. If you have some you started from seed or from plants, then it really depends. If you're after really large onions, you want to start them from plants or from seed, because what you want are intermediate day onions. They bulb in response to day length. And so all the sets are going to be short day plants, which means they're going to start to bulb early before they have a whole lot of growth. If you look at an onion, every leaf you see means a ring on that onion. And so when they start to bulb early, you don't have a lot of leaves, therefore you don't have a lot of rings, there you have smaller onions. So if you want larger onions, get an intermediate day onion. That include things like Candy and Superstar. Those are intermediate day, and you'll get some really large onions, larger than what you used to. Smaller onions are fine. There's nothing wrong with them. But if you want larger ones, try to go with that.
We think of these as being pretty hardy, but I'm assuming there's still some care involved.
There is. You really have to push onions also in order to get the size you want. And so you're keeping them well watered because they have a very restricted root system, and you fertilize them several times during that growing period. Now, as soon as they start to bulb, you stop fertilization. You want all that energy that's stored in the leaves to go back into that bulb. When they get to full size, that's when you start to harvest.
Any particular type of fertilizer we're using here?
It doesn't really matter, but usually you're going to use something like a balanced fertilizer at the beginning, unless the soil test says you don't need it. And then you'll use a high nitrogen fertilizer in order to side dress those extra fertilizations. And so when those onions are mature, about half those tops are going to fall over. That's your sign that they're full size. And so at that point, that's when you're going to pull them out of the ground. Now, what you have to realize is that they can get sunburned. And so you're going to need to, once you pull them, you're going to need to pull them and put them in a shady location where they have really good air movement. And so what I do is I have a kind of a box with a false bottom that has woven wire on it. And therefore I can put them in there and they'll go ahead and dry that way.
So they need to be dry.
Yeah. You want those tops to be completely dry. And that can take a while. It can take 2 to 3 weeks, depending on what type you have. If you have a very thin top, it won't take as long. But some of the larger tops where you have a big base to that bulb, then, yeah, it can take quite a while. So just make sure you keep them there, well ventilated, until they are completely dry.
And then you eventually remove the tops?
Yeah, you can. Now, some people will weave them together and hang them. You don't have to do that, but that's just personal preference. And when you store them, make sure you don't put them in just plastic bags. They need to breathe. And so a mesh bag or something like that would work really well for them. And they'll last quite a while. They'll last into the fall. I've had some last clear into the next spring, but that's rare. Usually through the fall, maybe early winter, and that's about how long they'll last. And
then can you use that space in the garden for something else?
You can. If you're a fall gardener, that opens up that space so you put something else in. Some of our, like from sets, those onions are probably very close to being ready to be pulled. But something like the intermediate day, like the Candy and the Superstar, usually that's about the first week, maybe second week of July when you pull them. Still have plenty of time to put it in the fall garden.
Now, of course, they can find more information online.
Yes, they can. And so we have on our newsletter, we have all that information written. If you want to find that, just do a search on Horticulture Information Center, Kansas. It'll pull right up, and then you look at our newsletter.
That's K-State horticulturist Ward Upham with information on harvesting onions. Tomorrow he has advice for keeping raccoons away from your homegrown sweet corn. And that'll do it for this edition of Agriculture Today. For Samantha Bennett, I'm Jeff Wickman. This is the K-State Radio Network.